every appeals court that ever looked at Jens Soering's case refused to overturn his conviction, so there must be absolutely no truth to his claims of innocence. I keep hearing that, and that's why I'm making a video about it today, because it's complete nonsense. The subject of this video is the appellate system and the habeas corpus system in the United States, and why it's almost impossible to prove your innocence generally, and also in my case specifically. The simple fact of the matter is that at no time was I ever able to bring new evidence of innocence into court. No judge ever looked at any of the new evidence. It was not legally allowed. So the statement that all the appeals courts refused to overturn my conviction is factually true. But what does it mean if the appeals courts were never actually able to look at the new evidence? They only looked at procedural errors and constitutional issues. At no time did they ever look at the new evidence. And I think that's not very fair. But follow me in this video. It's going to get pretty technical. That's why I need some paperwork here. I can't remember all this stuff. I'm an old man now. It's an interesting journey into the American legal system, and you can really learn something about how the system works. Let's remind ourselves, what is the new evidence in my case that the judges never looked at? The first thing is the footprint of Elizabeth Haysems. That's the first piece of new evidence. I did a video about that, remember that. There are the two reports, affidavits by experts, Russell Johnson and Frederick Webb. Also evidence of innocence that never made it into court. Here we see the DNA tests. Then there's the FBI profile. Here you see a page from the FBI file. The actual profile itself was not found, but that refers to the FBI profile. The new witness, Tony Buchanan, here you see him. He said he saw Elizabeth with a bloody knife and a man who was definitely not me. Could never bring it into court. The luminol test, the getaway car. Here you see the radio report on Ricky Gardner talking about the luminol test. No blood in the car. Then there was a scientist who looked at the reliability of my confession. Here you see him, Dr. Andrew Griffiths. Could never bring that into court. And then there were two scientific reports by Professor Moses Shanefield and by Professor Tom McClintock. Their DNA reports also never made it into court. Then they found a second shoe print at the crime scene. Could never be brought into court. And there is also, here you see her, a new witness who says that she heard two men, say that they committed the crime with a rich woman together. And that also never made it to court. All of this new evidence was never brought before a judge. Nobody ever ruled on this. Look, some of this evidence may not be that reliable. We don't know, because it was never examined by a judge. Some of this new evidence may be super reliable and total exoneration. We don't know, because it was never brought in front of a judge. What you need to realize is that in this respect, my case is not at all unusual. It's completely typical for the way criminal convictions are handled in the United States, unfortunately. Nobody knows exactly how many innocent people there are in prison today, because there's simply too many of them. Remember, there's about 2 million jail and prison inmates together. The precise technical term is total correctional population. There's about 2 million inmates in the United States. Here you see a statistic from the Prison Policy Initiative. That's a really, really excellent source of information about the prison system in the United States. So you cannot look at 2 million people, it's just too many. You have to pick out groups and work on them, and then basically apply that model to the general prison population. And there are 3 studies that are recognized as being reliable on the percentage of wrongful convictions. The first one, you see it here, is by Professor Samuel Gross at the University of Michigan, 2014. He looked at 7,482 death penalty cases, and he came up with 4.1% wrongful convictions. So 4.1% of the death penalty cases he looked at, the people were innocent. Here's the second study. It's by John Roman, Kelly Walsh, and others with the Urban Institute for the Department of Justice, Federal Department of Justice, 2012. They looked at 634 murder and sex crime convictions in Virginia, which is interesting for me because, of course, I went to court in Virginia. I was in prison in Virginia. So this applies directly to me. And they determined a wrongful conviction rate of 5% overall, and for sex crimes, 8 to 15%. And here's the third study. It's by Kelly Walsh and Jeanette Husserman. It's also for the Federal Department of Justice, but it's out of the Office of Justice Programs, 2017. It's a continuation of the second study by the Urban Institute. And Kelly Walsh found a wrongful conviction rate of 11.6%. 11.6%. Here, I'm showing you something from the Innocence Project. They determined a wrongful conviction rate specifically for Virginia for 6%. Now, for the rest of this video, I'm going to be taking that number because remember, we had 4.1% with Professor Gross and 11.6% with Miss Walsh. And the 6% are somewhere in the middle there. It's more towards the lower end, but for the purposes of this video, let's say that's good enough. 6% is probably a little conservative, but we'll use 6%. Remember, we have 2 million inmates nationwide. 6% of 2 million is 120,000. There are 120,000 innocent people in prison today in the United States. 120,000. And that's pretty much generally recognized in the legal community. Nobody talks about it much, but this figure of about 100,000 innocent people in prison, a little more, pretty much everybody agrees on that. What was it like in Virginia? These are the national figures. What was it like in Virginia? We're going back to the Prison Policy Initiative. You see it here. They give a figure of 69,000 prisoners in Virginia, but you have to subtract out 8,000 of those because those are federal inmates. There are federal prisons in Virginia, but you can't count them as Virginia inmates because they were not brought in front of Virginia courts. Actual Virginia prison inmates, or Virginia inmates generally, jail and prison inmates, you have 61,000. So you apply the figure of 6%, 6% times 61,000, you come to 3,660 innocent people in prison in Virginia today. While you're watching this video and while I'm making this video, 3,660 innocent people in Virginia today, behind bars. If the appeals courts and the federal habeas corpus courts were actually working properly, why are there so many innocent people in prison in America? Why? There's some reasons for that, and we're going to look at them now, okay? The first reason is a completely understandable human reason. It applies to you and it applies to me. And it's this: nobody likes admitting a mistake. I know I don't, and I don't think you like admitting a mistake either. And the same thing applies to the appeals court judges. It's human. Nobody wants to admit a mistake. That's reason number one. Reason number two, the problem is too big to solve. And we've all encountered this concept in other areas of politics. There are just some problems that are too darn big to solve. So you ignore them and you push them away. This problem is much too big. There's no solution possible. You have 2 million prison inmates and you're supposed to find the 120,000 innocent ones among those 2 million. How are you supposed to do that? I mean, you play that through in your mind. Basically, you would need 3 people maybe per case to look at it and investigate. To find the 120,000 innocent people, you would need 360,000 investigators. Where are you going to find 360,000 investigators? Can't do it. The problem is too big. You can't solve it. So, instead of trying to find the 120,000 innocent guys and women among the 2 million inmates, you just push it away, ignore it. Now we come to the third problem. If the appellate court judges, the appeals court judges, and the federal habeas corpus judges, if they were to admit that over the past decades they've sent 120,000 innocent people to prison, that calls the whole system into question. Basically, if your legal system is producing that many mistakes, the only real solution is to tear the whole thing down, fire everybody, and start from fresh. But that means that you, as an appeals court judge or a federal habeas corpus judge, you lose your job as well, because you're part of the problem. Those 120,000 innocent people didn't get into prison by themselves. You, the judges, put them there. So the way to solve the problem is to let's start by firing all the judges. It's actually the only sensible move. No appeals court judge is going to agree to that, and no federal habeas corpus judge is going to agree to that. They're going to say, no, we did everything right. There are no innocent people in prison, because if there were, we'd have to lose our job. Fourth reason why nobody wants to solve the problem of all these innocent people in prison. I spent 33 years in prison. Virginia pays about $46,000 per year for wrongful convictions. It's actually recently been raised, but Virginia's cheap, so it's still not a lot of money. Point is, that would have entitled me to about $1.4, $1.5 million for the decades they stole from me. I did not get that because I was not declared innocent. But that gives you an idea of how much money is at stake. In my case, it would have been $1.4 million. Now, take a look at your average case. Let's say the average case is not 1.4 million. Let's say the average case, 500,000. Let's just say 500,000. And you apply that figure of 500,000 to the 120,000 innocent people in prison. On average, every one of those 120,000 innocent people should get $500,000 for the years and decades stolen from them. Do you know how much money that is? $60 billion. Guess what? No politician, nobody is going to give $60 billion to people in prison who were wrongly convicted. It's just not going to happen. It's too much money. They're not going to do it. So again, best solution, deny the problem. Pretend it doesn't exist. In Virginia, it costs about $21,000 to house one inmate for 1 year. That's chump change. It's much cheaper than actually releasing the innocent. Just leave them in prison, pay the $21,000 a year to keep them there, and pretend the problem doesn't exist. And that, folks, is the way the appeal system works. Now, of course, once in a while, they do let people go. You see it on TV every couple of months, there's somebody getting released somewhere, right? Let's look at how many actually do get released. Here you see the National Registry of Exonerations. I'm making this video at the end of 2022, and at that point, the National Registry of Exonerations had 3,300 recognized wrongful convictions, officially recognized. 3,300 from 1989. So that's 2022, 33 years. 3,300 wrongful convictions. We're talking about 100 people per year, on average, over the 33 years, getting released because their wrongful conviction has been recognized officially. That's not bad. Every 3 days, somewhere in America, a wrongfully convicted person is getting released from prison. At that rate, 3,300 since 1989, that means every 3 days, some innocent man or woman is getting released. But let's remember, it's 100 per year getting released, and there's 120,000 innocent people in prison. So that's basically 1 out of 1,200 getting released. Less than 1 out of 1,000 are having their wrongful convictions recognized. That's how low the percentage is. That's nationwide. What's it look like in Virginia? Here you see it. Since 1989, 68 people have had their wrongful convictions officially recognized. Official victims of miscarriages of justice. 68 in 33 years. Do the math. It's about 2 per year. 2 per year. Out of 3,660 innocent people in prison. Again, it's less than 1,000. Less than 1 out of 1,000 innocent people is getting released and officially recognized. That's what's actually happening. They're letting 1 out of 1,000 go, and the other 999 get to stay in prison, even though they're innocent. Why is it so difficult to get a conviction overturned if you're innocent? There's a fantastic video about this by John Oliver. I've shown you a little screen here. You've heard of John Oliver, of course, Last Week Tonight with John Oliver. I think it's had like 4 million views on YouTube. Brilliant. Much better than my video here. He explains it all. It's basically impossible to get out of prison once you're convicted. Don't believe me? Believe John Oliver. I'm going to tell you about the situation in Virginia and my case in particular. Virginia is unique because it has something called the 21-day rule. No other state in the United States has a 21-day rule. It's unique to Virginia. And here you see it, and in the next screen you see a dissertation about the 21-day rule. What does it say, the 21-day rule? It says that if any new evidence of innocence comes to light more than 21 days after the end of the trial, you cannot bring it to court, ever. No judge will ever look at it. They cannot. How does this work in practice? What the rule actually says is that the circuit court loses jurisdiction of the case 21 days after sentencing. And that means that if the new evidence comes to light more than 21 days after sentencing, you can't take it back to the circuit court. He's no longer responsible. He doesn't have jurisdiction. Now, you're probably thinking, okay, well, if the circuit court doesn't have jurisdiction, somebody else does, right? Nope. It's not the way it works in Virginia. Once the circuit court loses jurisdiction, that's it, done. They're done with it. There is no more jurisdiction. They're finished. You can't ever bring new evidence to court. That's the truth. Why is it like that? That dissertation that I just showed you explains the reasons why. Finality. What they care about in Virginia is finality. They want judgments in trials to have finality so that other people can count on that judgment, that verdict, being there years later. You can rely on it. And that's actually not a bad idea. You need to be able to count on verdicts having some finality. But in other legal systems, they balance that out with some chance of review if the verdict is wrong. In Virginia, they just got rid of the second part. There's the finality of the judgment, and that's it. And they say it. It's in this dissertation that I showed you earlier. They say that. They want the jury's verdict to stand, and that's it. Nothing if it's more than 21 days later. And all of the new evidence that I showed you earlier, all of the new evidence in my case came to light more than 21 days after sentencing. Now, the 21-day rule obviously leads to miscarriages of justice. And so every few years, the Washington Post, and here's an article about it, campaigns against the 21-day rule. Because every few years, there's another poor guy like this man here, but the Washington Post does this every few years because these cases keep happening. He can't get out of prison because of the 21-day rule. And what the Washington Post apparently doesn't realize is that Virginia is not going to change this. They want it that way. This is not an error in the system. They just have a different value system in Virginia. They want finality. And if innocent people have to suffer for that, that's okay with them. Finality is more important. But my point is, people do recognize that there is something going on, that there's a problem with this 21-day rule. They just don't want to change it. Let me tell you about how that's looked in my case with the ink footprint of Elizabeth's that I talked about in the other video on sock print evidence that I did. After my trial, my lawyer found an ink footprint of Elizabeth's that fit the sock print at least as well as mine, from the length actually better. And he filed a motion for a new trial. He submitted it to the judge, and the judge turned it back. He refused it because my lawyer used the wrong legal formula. He wasn't supposed to call it a motion for a new trial. He should have called it a motion to set aside a verdict. He used the wrong term, the wrong terminology. So the judge turned it down. So my lawyer resubmitted it as a motion to set aside the verdict, but now it was over the 21 days. And so the judge turned it down again because of the 21-day rule. And the ink footprint of Elizabeth Haysam's has never been examined by any judge at any point ever. Nobody's ever looked at it. They can't. Nobody's responsible. The jurisdiction of the circuit court ended 21 days after the trial, and nobody else has jurisdiction over it now. There's no court to hand it in. The Virginia legislature, the General Assembly, recognized that they had a problem with optics here. So they created exceptions to the 21-day rule. What they should have done is just get rid of the 21-day rule. They didn't do that. They created exceptions so that they could say, hey, we addressed the problem. But I'll show you they didn't. These exceptions to the 21-day rule are called writs of actual innocence. A writ of actual innocence is a way to file an appeal outside of the 21-day rule. And the first writ of actual innocence was created in 2001. It's for DNA evidence. And I'm making this video in 2022, 21 years later. Guess how many people managed to get out of prison with a writ of actual innocence for DNA evidence in those 21 years? 13. 13 victims of wrongful convictions in 21 years. And there are 3,660 victims of wrongful convictions in prison. In 2004, the General Assembly brought in another exception to the 21-day rule. It's a writ of actual innocence for non-DNA evidence, new witnesses, stuff like that. So again, it's 2022 now that I'm making this video, so that has been in force for 18 years. Guess how many people managed to win their freedom and have their convictions overturned in those 18 years with a writ of actual innocence for non-DNA evidence? 4. 4 in 18 years. So you put them together, in 21 years, 17 people have managed to win their freedom and have their convictions overturned with this writ of actual innocence. 17 in 21 years. And we know there are 3,660 innocent people in prison. The General Assembly understands that this is not working, so they tried to reform these laws, the writ of actual innocence. They tried once in 2012, they changed some words, and they tried again in 2020, changed some more words to try to make it a little easier to win these writs of actual innocence. It hasn't changed anything. Why? The law has changed a little bit, but the people applying the law, the judges on the appellate courts, are still the same judges, and they don't care. They are still turning down writs of actual innocence like they've always done because they are not going to admit a mistake was made. The hurdles in these writs of actual innocence, the legal hurdles, are so high, you just can't meet the burden of proof. All of the evidence that I showed you in my case, the new evidence of innocence, I don't have a chance with any of that. That's the way the law is written. It's not supposed to work. It's a pretense of a solution. Again, there's a simple way to solve this. Get rid of the 21-day rule, but they're not going to do that. They're not going to do that. So all that's left is appeals and habeas corpus. Habeas corpus is kind of like an appeal, but it relies on the US Constitution, right? Constitutional errors. That's what habeas corpus is. But again, both of those only deal with procedural errors, like insufficient evidence or jury instructions and stuff like that, or constitutional issues, like ineffective assistance of counsel or Brady violation. None of this has anything to do with innocence. Innocence is not a subject of appeals or of habeas corpus. And that's not just me saying it, it's the US Supreme Court saying it. There's a really famous case called Herrera versus Collins. It's from 1993, and it says that claims of actual innocence have never been held to be the grounds for habeas relief. And in a weird kind of way, that actually makes sense. The purpose of habeas corpus is to find violations of the US Constitution. And if you think about it, innocence really doesn't have anything to do with that, because innocence is not a violation of the US Constitution. It's sick, but somehow logical. So in 1993, they actually executed, his name was Leonel Torres Herrera, even though he was probably innocent, because there was no constitutional violation at his trial. You think that's crazy? The US Supreme Court just upheld the principle and expanded it in another case. We're talking about a guy called Barry Lee Jones. He's on death row in Arizona. Here you see an article about his case, and you can see what it says. The judges never ruled that the evidence of innocence was somehow unconvincing. Instead, they said the federal habeas corpus courts were barred, forbidden from even considering this evidence of innocence. Clarence Thomas wrote the decision. Again, in a strange sort of way, it makes sense, except that it's totally crazy and sick. So let's talk about these procedural issues and constitutional violations. How do these courts look at this stuff? How do they deal with it? Here you see a picture of Bill Sweeney. That was the judge at my case. He was a friend of the victim's family, grew up with the brother of one of the victims, and remained friends with him for over 40 years. That's not what's at issue here. Here you see the front page of a magazine that published an interview with a judge. And you see here the excerpt from that interview. This was published on the first day of my trial, on June the 1st, 1990. That magazine appeared right there in Bedford County. People could buy it. And it said, you see it here, that the judge offered a scenario of how the murders may have occurred, and he said that he thinks Elizabeth Haysom was surprised that I took the dare, and what he meant by taking the dare is killing her parents. So he had made up his mind. He had made up his mind that I had taken the dare and killed Derek and Nancy Haysom. And you'd think that maybe that's not okay for him to be a judge. But that's not the way the Virginia appellate courts ruled. Here you see an excerpt from a legal book that explains why. In Virginia, judges rule on their own lack of bias. And if the judge himself says, I can be fair, then the appellate court judges are not going to tell him different, unless there's a gross abuse of discretion, which you cannot prove. You actually have to have a picture of the judge taking a sack of money for abuse of discretion. Judges get to decide their own bias or lack of bias, their own fairness. And Judge Sweeney decided he can be fair, even though he'd already made up his mind, and my appeal was denied. And my attorney, who was a really bad attorney, made a mistake during the appeal process. He did not mention that this whole issue had a constitutional component. It's called federalizing the issue. My lawyer didn't do it, which meant that this whole issue with the judge could never be brought during habeas corpus proceedings afterwards. So this is the second time that my lawyer made a serious mistake in the way he formulated things, in the way he expressed them, in the legal terminology. The first time was with a petition for a new trial, which should have been a motion to set aside the verdict. And now here, with the judge, he failed to federalize the issue. And both of those things were just serious legal errors by my lawyer, which I had to suffer for. That's the way it works. He screwed up, and I'm the one who gets to stay in jail. Here's a picture of the man. His name is Richard Neaton. On November 21st, 1995, the disciplinary committee of the Bar Association ruled that he would have his license suspended, and eventually he lost it altogether. He was found guilty in 4 of 6 counts in the indictment. Among those counts were that he misappropriated $5,000 of mine, and he handled my habeas corpus petition incompetently. For some reason, some people who have pronounced themselves to be experts on my case, in some cases even the world-renowned experts on my case, are now claiming that my attorney lost his license for reasons that had nothing to do with my case. I have no idea why they're spreading this nonsense. It's definitely not true, and you should ask yourself, why are these people telling you things that are obviously not true? Something called Google. Try it out sometime. Here's the first article, which says clearly he lost his license because of mistakes he made on my case. Here's the second article that says clearly that he lost his license because of mistakes he made in my case. And here's the judgment from the Bar Association's disciplinary committee. Found guilty. Stuff that he did in my case that was wrong, like the $5,000 and the incompetence. So, here's a really funny situation, right? The Bar Association says that he is so bad that they're going to take away his license to practice law. You'd think that maybe I'd get a new trial out of that, right? But the federal habeas corpus courts looked at it and they said, yeah, we can't deny he lost his license because he's so incompetent. But he's not incompetent enough for you, Mr. Soering, to get a new trial. Yeah. So, I really don't need to comment on that any further. I think it speaks for itself. He's so bad a lawyer that he can't practice law, but he's not bad enough to grant me a new trial. What a system. What a system. I think we can honestly and fairly call it an injustice system, not a justice system, right? Since the legal system doesn't help people, what other option is there? The only other option is a pardon from the governor. Pardons are not a judicial process. It's not a legal process. It's just an act of mercy by the governor, right? And because the governor is a politician, it's always done on some extent on political grounds. Because it's not a legal process, you do not have a right to a lawyer. You do not have a right to see the evidence against you. You have no rights. In my case, my pardon petition took 3.5 years almost. The governor had assigned the task to looking at all of the pardon petitions, all of them, right? To one part-time employee. She was an ex-police officer who was injured on the job, and she was now working for the governor looking at these pardon petitions. A part-time employee for all of the pardon petitions in Virginia. That's why it took 3.5 years. Now, of course, I've heard from some quarters, well, Governor Ralph Northam, who released me on parole, Governor Ralph Northam granted 1,200 pardons. If you were really innocent, then you would have gotten one of those 1,200 pardons. Really? Once again, the people who make these claims, who say these things, obviously don't know how Google works. It's not hard. Maybe I should do like an online coaching for them. Here is an article about this, all right? The governor granted 1,200 pardons. But then read a little bit on. Only 8 of those pardons are for prisoners who spent a long time in jail for crimes they didn't commit, which is what you usually think of as a pardon. So what were these other 1,200 pardons that the article talks about? They're called restoration of rights. In Virginia, if you get convicted of a crime, when you come out of prison, you don't have a right to vote, you don't have a right to own a firearm, any of that stuff. And you have to apply for a simple pardon, restoration of rights. That's what Governor Northam did a lot of. And it's good, okay? There's nothing wrong with granting simple pardons. It's important, but it's not what people usually think of when they talk about pardons, which is correcting wrongful convictions for people who've spent years and decades behind bars for something they didn't do. Actual pardons in that sense, real pardons, Governor Northam granted 8. 8 in 4 years of office, so that's 2 pardons a year. 2 pardons a year. One more time, and I'm sorry if I'm boring you, there's 3,660 wrongfully convicted people in prison in Virginia. And Governor Northam exonerated 2 per year, total of 8. What does the system do? When the system recognizes that there are people who are obviously innocent, but we don't want to admit that we made a mistake. The system has come up with 2 solutions. One of them is called the Alford plea, the other one's releasing somebody on parole, which is what they did with me. Let's do the Alford plea first. The Alford plea is a really evil thing. Here's a long article about it in the Washington Post. The Alford plea basically means that in order to get out of prison, you have to admit being guilty. Yeah. The Washington Post article explains that they really like doing this. They do it everywhere, but the place where they really go crazy with this stuff is in Louisiana. And there's really sad cases in there of 42 years behind bars. And so the prosecutor comes to him and says, look, you can fight to be exonerated, and we'll be in court for another 2 to 3 years for you to clear your name. And you've already spent 42 years in prison. You can spend another 2 or 3 years, and maybe you'll win, maybe not, but you might win. You might get exonerated. Or you can take an Alford plea right now, and you get out immediately. But you don't get to clear your name. You have to plead guilty all over again. And a lot of people took that. And there's a story in there of one unfortunate man who took an Alford plea and couldn't live with the decision later on and actually committed suicide. A really famous case of an Alford plea is the West Memphis 3. I don't know whether you remember those. They made a bunch of Netflix documentaries about them. They are 3 teenagers in Arkansas, and it turned out they were innocent. I think they spent 18 years in prison. And in order to get out, they made them take Alford pleas too. They had to say, once again, that they were guilty. And if they said that, they got out right away. And so they did that. I would say you have to be a real sick son of a gun to come up with something like that, but they do it all the time. They do it all the time. What's the other way to get innocent people out of your prison without having to admit that you messed up? Releasing somebody on parole. Here is a long article about it. This is also something that happens all the time. Innocence projects across the country work on different cases, and people then are released on parole without their innocence being recognized. They're just released on parole, and they still count as a convicted felon. In Virginia, there's a really famous case called Darnell Phillips. Darnell Phillips, I'm linking you up a podcast with him. Darnell Phillips is so ridiculously innocent that even the victim in his case wants him declared innocent. Even the victim thinks he's innocent. That's not what he got. He got released on parole, and he is now free in Virginia, but he's a registered sex offender, which means that he's restricted where he can live. He cannot go to public parks. He can't go near schools and stuff like that, even though he's totally innocent. But it's cheaper and less controversial, and you don't have to admit a mistake if you release him on parole. And that's exactly what they did with me. They released me on parole too. What a system. What a system. So, the next time somebody tells you that all of the appeal courts denied Mr. Soering's appeals and habeas corpus petitions, they looked at his conviction and they think he's guilty, so obviously he must be guilty. When you hear that, please remember this video, and if somebody else says it, please ask them to look at this video so that people can decide for themselves. No court ever looked at the evidence of innocence in my case, and the system is profoundly, profoundly broken.